Now, the Madhya Pradesh High Court has gone on to rule as unconstitutional a provision in the Madhya Pradesh Freedom to Religion Act 2021 that requires an individual to give a declaration to the district magistrate before undertaking the religious conversion. Now, the interim order comes as a relief for all the interfaith couples in the state who are entering into wedlock. The MP High Court has restrained the authorities from taking any coercive action against the persons not meeting the declaration requirement. Now, the interim order was passed. Remember, when the High Court was hearing 7 petitions by the activists and the social workers who sought a stay on the MP Freedom of Religion Act 2021, stating that it was in contrast to the fundamental rights under the constitutional and granted unbridled and arbitrary powers to the authorities. On this note, Govind joins me live from Bhopal. Govind, a very good afternoon to you. अब आप पहले हमें तो बताएं कि पहले था क्या exactly ये जो rule था, ये था क्या? अगर आप हमें ये पहले बता सकते कि what was the declaration required for all the interfaith couples, and also MP High Court की क्या observation रही है इस पे exactly?
Whatever we talk about the observation of Madhya Pradesh Jabalpur High Court, in fact, it's not that the High Court has challenged all the act. In fact, Section 10 of Madhya Pradesh Freedom of Religion Act 2021 has been challenged by High Court by declaring it unconstitutional. In fact, the court has declared and clarified that if two adults are mutually consent to get married or conversion of religion, so they are free for taking their decision accordingly. But before that, they have to inform the DM of the district before getting married or whatsoever, if we talk about the conversion and other things. So this is what 60 days ago these adults have to inform to the DM. But whatever the section says in 10 section of freedom of religion is having a different opinion by Jabalpur High Court. So this is what a kind of interim order. In fact, it's not the final order, which has been challenged by Jabalpur High Court.
Absolutely. So that was my colleague Govind, who's reporting live from Bhopal. Govind, thank you so much for your time and inputs on this. I'm also being joined by Advocate Chirag Nayak, a legal expert. Sir, a very good afternoon to you and thank you for making time for Mirror Now. Now, I want to understand from you here that the MP High Court has gone on to term this declaration for all the interfaith couples who want to enter into a wedding lock as quote-unquote illegal and unconstitutional. So I want to understand from you here that what does the Constitution say in such cases, and does the state hold the power and the authority to make such changes, to make such amendments?
Good afternoon, Pooja. Thank you for having me. I think what the Madhya Pradesh High Court has observed, I would like to clarify here, is only that they have prima facie found that the provision under Section 10, which requires a person who's intending to convert to give a 60-day notice to the government, and the religious person who's going to organize the conversion to give a notice to the state for 60 days in advance before organizing the conversion. That has to be done. That section has been held to be prima facie unconstitutional by the court. It's not a final determination, and the court has given 3 weeks for the state to reply on that petition. So the battle is far from over. But of course, there are prima facie concerns on the declaration bit of it. Of course, nobody is challenging the intent of the law, whether fraudulent or forced conversions are illegal or no. I think the position is very clear. Nobody can be forced to do anything in this country, not even eat against their will. So if that is the legal position, only point which the High Court is considering here is whether an advance notice has to be given to a state, and whether a person under the constitutional principles is liable to answer to anybody about his religious beliefs. So on that point, the High Court is considering this legal proposition.
All right. Got the point there. But I also want to understand that in such cases, does the Constitution empower the states to make such changes and amendments, which can be then overturned by the courts?
Let's understand the law. So the Madhya Pradesh Freedom of Religion Act has been made with a view to curb conversions from one religion to another by misinterpretation, allurement, use of threat of force, undue influence, coercion. So, to stop illegal activities, there are people who are just don't understand the implications of their conversion. They are paid to do so. There are sometimes people are forced to convert in circumstances. There could be psychological pressure. So there are various things happening in society. So it is to curb those ill wills. But to blanketly mandate that every person intending to convert should give a public declaration, I think that's going a little too far, and that is an invasion of right to privacy of an individual. So here we'll have to balance the right to freedom of religion and right to privacy.
All right, one final question before I let you go. Just for the benefit of our viewers who are watching this right now, I also want to understand from you, what are the legal remedies in such cases if a certain couple of interfaith, wedlock is not comfortable abiding by this particular rule in a state where they have to mandatorily sign that declaration? Since their argument is that we are adults, why do we need anybody's consent? Why do we have to put out the proof?
Yes, of course, and they will be validly here. For example, the Madhya Pradesh High Court has specifically said that the state should refrain from prosecuting, couples who are getting married voluntarily. So, the court has for now protected these persons in Madhya Pradesh. In different states, the position may change, but I think this is under serious challenge. And I think I would encourage everybody to follow the law in their respective state. If a declaration is required, you must give it to avoid future complications. Because in interfaith marriages, the couple may be agreeable, but there will be family who may not be agreeable. So practically, it is much safer to follow the law, and it is the mandate of the law to follow the provisions of the law which is applicable to your marriage.
All right, Mr. Chirag Nayak, thank you so much for making time for Mirror Now and for sharing all your very interesting and insightful inputs.
Thank you, Pooja.